Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. As followers here know, I'm usually here with Ann Lipton, a law professor at the University of Colorado, who teaches and researches securities and business law. But Ann, alas, is away this week. I think she's got a paper she's presenting at some conference or something. Who knows? So instead, Ann and I invited Kyle Pinder, an attorney and a partner at the law firm of Morris Nichols in Wilmington, Delaware, to talk about a really cool and fascinating paper that he wrote recently. Hello, Kyle.
Hi, Michael. Thank you for having me. And I'm sorry Ann can't be here, but I'll try to fill in as best as I can. Those are big shoes to fill.
I think you will acquit yourself really well. And you are coming to us from Wilmington, Delaware, I think, right?
Yep. Live at the corner of 12th and Market Street in Wilmington.
In Wilmington, that bustling metropolis and center of corporate governance jurisprudence.
Exactly.
Kyle found himself in the news in the last few weeks after he got a really, I suppose, pretty good shout out from the SEC chair, Paul Atkins, about this paper that Kyle put together on the subject of how, I hope I get this right, how Delaware law looks at shareholder precatory proposals. Is that the right way to summarize it?
I think that's a great way to kind of to tee up the question.
Cool. So we asked Kyle on to talk about the paper and how it came together and what he found and maybe some other fun stuff. So that's what we're going to dig into. Before we do that, I just want to mention, this is usually Ann's job, but I'm going to do it today. We encourage everybody to get in touch with us. Send us your comments and your suggestions and your questions and your criticism. Send that to us at shareholder primacy, one word, at freefloat.llc. Once again, that's shareholder primacy at freefloat.llc. Please let us know what you think. Kyle, you can even do that too if you want.
That sounds good.
So
no, I'm a regular listener, but I haven't written yet. Maybe this will prompt me to.
This will be it. Yeah, you need to send us some email. Anyway, all right, let's start with the paper. The title of the paper, which I should say for everybody, and is available in draft form now, or working paper form at ssrn.com, is called The Non-Binding Bind: Reframing Precatory Stockholder Proposals Under Delaware Law by Kyle A. Pinder. So let's start talking about it. What did you find? What was sort of the main conclusion from all the work you put into this?
Yeah, so I think like the top line takeaway is that Delaware law is, candidly just silent or absent on this topic, as are most states, because it really doesn't come up all that much
on the subject of precatory proposals.
Exactly, and whether those are a proper subject for stockholders to raise and bring at a meeting. At
a shareholder meeting at AGM.
Exactly. An AGM, or I guess theoretically a special meeting, but those few and far between.
So Delaware law, I think what I hear you saying is doesn't really, there's not much in Delaware law, Delaware statutes, Delaware case law that even talks about precatory proposals. I think that's part of what we found. Is that right?
That's right. So I think you start for most questions with Delaware law, it's the Delaware General Corporation Law, which is the
DGCL,
code.
Right?
Exactly. The DGCL says absolutely nothing about non-binding or precatory proposals generally, whether it's shareholder or management proposals.
Okay. Now, before we dig into that, most everybody who follows this would know what a precatory proposal is, but just let's establish that. Take 10 seconds and define for us what we mean by these.
Yeah. So a precatory proposal or a precatory shareholder or stockholder proposal is a resolution the stockholder would raise at a meeting and effectively make a request or a recommendation to the board. This resolve the shareholders request that the board prepare a report on greenhouse
climate
gas
or something. Yeah, right.
Exactly.
Or that the board, make every effort to create a diverse workforce.
Exactly.
Or it could request the board amend the bylaws in a certain way.
That's exactly. And that's a big distinction, I think, among among the different types of these kind of non-binding or precatory proposals.
Yes.
There are ones related to environmental, social, civic, political issues.
Yes.
And then there are the governance proposals, like the
Yes.
true governance proposals. We request the board take all necessary action to destagger and eliminate the classified board.
Right, yeah.
Exactly. But we'll get into. I think your listener, you and Anne really did a great job explaining it to the listeners. But when Chairman Atkins gave his speech in Delaware, it was focused on the environmental and social proposals.
Right. But I think you're making a broader statement about any kind of precatory recommendation or whatever is what's on the table here.
Right.
And you in the paper you went into all sorts of detail to say that basically Delaware law doesn't grant any kind of inherent right to a shareholder to have the board included on the agenda for shareholders to vote on it and so on and so forth. I think that's
exactly right. So going back starting at the statute, there's the DGCL.
Ahead,
there are two relevant provisions I think that could be cited one way or the other on this relatively novel question.
Yes.
The first one is Section 211B of the DGCL, which relates to annual stockholder meetings.
Okay, let me write that down real quick. 211B. Okay, go ahead.
Yep. So that authorizes the transaction of any, quote, proper business or other proper business other than the election of directors.
Okay.
And there are two ways to look at that. One is that's just a very broad catch-all that, anything and everything is, it's like Thunderdome. Anything can happen.
Shareholders can talk about all sorts of stuff at meetings.
Yep. And then the other section, and the other way to look at it is, it is a catch-all. It's proper business, but it's not defined. So you kind of have to look to the other confines of the statute to figure out what that means.
Yes. All right.
The other relevant provision is one that's near and dear to most corporate lawyers' heart is DGCL section 141A.
I was going to say 141, and I'm not even a lawyer. How's that?
Yeah, exactly. That's the one that gets all that gets all the press. So that's the provision that confers on a board of directors the power and authority to manage both the business and affairs of the company.
Right. Okay. So and those are really very kind of basic in general. I mean, the word precatory proposal doesn't come up any place, or proposals or whatever in either part of those statutes. Okay.
But I think it kind of how one looks at the interplay of those two sections, or generally how 141A flows through the DGCL.
Yes.
That's going to color, I think, where someone's going to come out on this question, whether they agree with me or if they take the contrary position.
Yeah. Okay. Oh, interesting. All right. So there's those two parts of statute.
Yeah.
That
and historically,
could conceivably bear on this question.
Exactly. And I think historically, the Delaware courts have, in interpreting Section 141A, they've adopted nomenclature such as Delaware subscribes to a board-centric governance regime.
Yeah. Right.
So, I mean, and when you hear a term like board-centric and, managerial primacy, that kind of pushes you, at least from the kind of practicing here and thinking about how boards operate and how decisions are made, that pushes us to kind of view 141A as almost like a gap filler. So it is, yes, okay. you have all the authority that the board has under the code, but on top of that, to the extent there's silence, a board-centric governance regime would suggest that in the absence of express delineation of authority, that authority rests with the board.
Okay, so the boards can sort of, in some sense, do what they want here.
It's the difference. It's the theoretical difference or the debate between director primacy and shareholder primacy.
Right. And here we're about shareholder primacy here, but we can talk about that in a little while. Along some of the implications. All right, so keep going. So those are the two parts of statute that bear on this question. Are there other parts of the law that you needed to read to kind of get to your conclusion?
Yeah. So exactly. That's kind of where from there it's like, well, that tees up the framework for the question, but it doesn't really answer it.
Right.
So then from there, looking at Delaware law and shareholder rights generally, the way courts have articulated those in the past there are three fundamental rights. Okay. There's, when you buy shares, it confers on you the ability to do three things: to vote, particularly in the election of directors, because that is and has been considered the most important,
that's the most important subject for your votes. But we vote on other things. But voting generally is a right.
Voting generally.
Right.
The right to sell your shares. So the Wall Street rule. If you don't like what's going on, you can leave.
Wall Street walk, you can leave. Yeah, right.
And then you have the right to sue. So
so that gives you so owning shares gives you, as we would say, I've learned the word standing. Correct.
Yeah. You have the right to, you are owed directly fiduciary duties by the board. So if there's an action that I'm not a litigator, so the nuances of direct and derivative claims and when a claim belongs to the company.
That's for another podcast.
Effectively, But when you own the share, you have the right to monitor board performance and to influence that through
litigation.
Suit. Exactly.
So vote, sell, sue. Vote, sell, sue. Okay.
Yeah. So those are very, very broad topics, and the right to vote. It's. The question then is like, well, what do you get to vote on? It says you get to have the right to vote, but what kind of things do you get to vote on?
Right. And does that right to vote, broadly drawn, include the right of a shareholder? Does it sort of cover or extend to these precatory proposals?
Well, exactly. So they're related questions. So from the fundamental rights, and we'll touch on this first. The Delaware courts have acknowledged subsidiary rights, and those are rights that flow from the right to vote, and
they're related to. So Delaware courts over decades have interpreted it to mean what you're about to talk about.
Yeah, when I think subsidiary right, it's essentially the fundamental right would be meaningless if you couldn't take the action granted by a subsidiary right. So you have the right to vote on director elections. That's kind of stupid if you can't nominate your own slate.
Oh, okay. Oh, interesting. So an extension of the right to vote on directors is the right to nominate directors.
Exactly. And you have the right, stockholders have the right to unilaterally amend the bylaws. That would be stupid if the only thing they could vote on were bylaw amendments the board says are a good idea.
Right. So the right to vote on a bylaw amendment indirectly
is the right to propose.
Right, to propose a bylaw amendment, which is a big project of mine or a big thing of mine. All right, go ahead.
Exactly. Yeah. So from there, in order for the precatory proposal right to be a thing, it needs to flow from the voting right. So that takes you to, looking at Delaware's voting rights jurisprudence.
Right.
To date, has the court ever acknowledged that stockholders have the quote right to vote on this type of precatory proposal that's not brought either, as required by law or by management?
Okay. Oh, interesting. So now, and the answer, all right, go ahead.
Yeah. The answer to that is, to date, no. The courts have not acknowledged that that's a voting right.
So you've looked high and low through all the cases, whatever, and you and others, you're not the first one to think about this.
Yep.
And have not really found the Delaware Chancery Court considering or taking a position on this kind of question.
Yeah. So the closest the Delaware Chancery Court, or the Court of Chancery, as my litigators yell at me if I said that.
Okay.
As they've come, is a case from the 1980s involving actually a books and records inspection demand, where a stop. At Chevron's 1987 annual meeting, a stockholder submitted a 14A8 proposal on a precatory proposal, requesting the company to cease their Angolan drilling.
Oh, right. Okay. Sure. Okay. Yeah.
A separate stockholder sought books and records to communicate generally about Chevron's, their drilling practices in Angola, and about that precatory proposal.
So they asked for under Delaware 220, which we can talk about another day. They demanded books and records on the subject of this proposal.
Yeah, they wanted the stock list to be able to talk to people.
Oh, interesting.
About generally Chevron's drilling practices in Angola, and more specifically, a separate purpose was to talk about the proposal.
Okay, sure. All right, go ahead.
So one of the arguments that Chevron, hard to say how hard they relied on it, but
Right.
the company said, well, it's not really something that's proper. So that's not, if the precatory proposal is not really a proper matter, then it's not a proper purpose for you to get a stock list to talk about.
Oh, interesting. Okay.
And so as an initial matter, the court overall just found the topic of the company's drilling practices is something that, is related to the stockholder's interests as a stockholder.
Sure.
So it is proper. It's a proper means to get books and records to talk to other stockholders about just the general business kind of decision. The court did in dicta, without citation, say, well, I guess the court, stockholders may want to have a vote on that, and there's nothing that's,
right,
uncouth about that.
Okay. But it didn't. Okay, but it didn't actually go out and say, okay, it didn't establish the right that we've been talking about. That's
it's dicta. It's a one sentence kind of maybe two sentence throwaway. So it's definitely it's support for the contrary view, but it's not controlling authority. So it's one that I address in the paper, but I kind of, for the high level reasons I just talked about, I don't view as answering the question.
All right.
So
all right, cool.
Going back to voting rights, though, I think
please.
To date, there are really three categories or three matters that the court has said, stockholders have every right to vote on these.
So these are three rights that flow from that right to vote we referred to.
Well, these are actually just the right to vote. So this is just these are the fundamental right. You get the right to vote on these things.
Oh, these three things. Okay.
Yeah.
And
so it's director elections, obviously.
Sure.
It's matters that are committed to stockholders for a vote by law or governing document. Okay. And law could be the DGCL. Right. Or, federal regulation or rule to the extent the company is subject to it. So,
right, okay.
To say on pay, vote for Dodd-Frank.
Oh, sure. So that creates
that is a federally mandated.
Right.
Yeah, that's a federally mandated.
Delaware has nothing to say about that. That's basically that was handed out from the SEC.
Exactly.
Okay. Right.
And then the last tranche of voting rights, or the categories of things stockholders can vote on, are those matters that the board is determined to submit or can be submitted for a stockholder vote.
So that's up to the board to decide what they want to hear from
auditor ratification.
About. Okay.
Right. Auditor ratification. You could kind of put like NASDAQ required votes in there. Those could. Sure. You can kind of think of those either as
exchange listing rules that
exactly.
For a vote. Okay.
Yeah, you can think of those as either quote committed by law because the company is subject to those standards, or the board has made a determination that we're gonna abide by those standards to have access to the public markets.
Oh, interesting. Okay. So those are sort of the three subjects for votes.
Yeah, and the board, I think whether they do it via bylaw.
Right.
Or policy or kind of one-off, a board can make a determination not to contest the stockholder's precatory proposal or not to object.
Right. They could allow whatever they want. But what your point is, you're coming in from a different direction.
You can't raise it over the board's objection.
So the board can, include or exclude at once. But if a shareholder will go to court of chancery and sort of litigate this question, Chancery would have almost nothing to work with. There's no statute to refer to and very little case law, but there's no inherent right that a shareholder would be trying to kind of enforce if it were trying to contest that board's decision to exclude it from the agenda. Okay, interesting.
Yeah. Whether it's the Court of Chancery in the first instance, or if it ends up at the Supreme Court first, kind of like the CA proxy expense reimbursement bylaw, it ends up there on a certified question first.
Yeah.
Admittedly, the court is going to be. They're going to have to write law.
All right.
And this is my framework is kind of how I think it should be answered.
So for those three things, importantly, there's nothing specific that says precatory proposals must be included. That's the key thing.
Correct.
Okay. Oh, interesting. All right. All right. So the paper also, delves into some other aspects of this that I want to make sure we cover, because we're gonna take a break here in a minute. That I want to make sure we cover before we do that. So there's a strong sentiment, at least among these proposers, that there's kind of public policy considerations that kind of override all this. That the climate stuff or the social justice stuff is just so important that it's critical that this be included. And I think you addressed that at least a little bit in what you wrote. What did that have to say?
So I think that two of the main policy considerations for 14A8 over time and precatory proposals generally is that they give a medium for intra-corporate communication. So for stockholders to talk to each other and for stockholders to talk to management about preferences.
Okay.
The other is holding management accountable if
Sure.
Management's making bad decisions or decisions the stockholders don't generally support.
Right.
We'll take it in reverse order. On accountability, reasonable minds can disagree.
Right.
But there are many more effective ways to hold managers accountable than
precatory
proposals that they can just ignore.
Right. Yes. Correct. So it's as accountability measures go, it's pretty weak.
It's pretty weak.
All right.
On communication, I think everyone can acknowledge it. It has been a going on nearly 100-year means of allowing stockholders to communicate on the company's proxy materials about matters that would be submitted to a vote. But 14A8, it was adopted in the 1940s.
Oh, sure.
So the amount of regulatory and technological development since then have kind of, some people think, left 14A8 in the dust. It's just not the most efficient or effective means of communication anymore.
Right.
You have universal proxy. You have withhold campaigns.
Right. There's other ways for shareholders to do this communication that go beyond this 500-word limited kind of proposal.
Exactly. Exempt solicitations. There's social media. There are a lot of ways that that weren't available in the 1940s, honestly, into the 2000s.
Right. Oh, interesting. All right. I have one other. I want to make a kind of a quick point here, just to make sure that I kind of understand what's going on here. Because the way I've been thinking about these proposals generally, but very specifically after looking at your reasoning, is that we need to make a distinction between what shareholders can consider as part of like a shareholder meeting agenda and what companies are required to include on the written proxy materials. The two are related, but they're actually distinct. And I think it's fair to say that your work on this pertains to the first question, pertains to what companies are required or not required to just include on the agenda, forgetting what goes in the proxy statement. Right? Is that a fair distinction? I think.
Yeah, it's exactly that. It's from a state law matter. What matters if there were no federal overlay and there were no advance notice bylaw.
Right. Yeah. Right.
What matters would be proper if a stockholder just stood up at a meeting and said, "I want to vote on this."
Right. Exactly. And importantly, the federal part of this pertains, I think, really only or almost only to the proxy materials. And that indirectly, by requiring something in the proxy materials, it sort of just defaults to needing to be on the meeting agenda. And you were then asking that very basic question about, let's talk about the meeting agenda.
Yeah, exactly. And 14A8 generally has been viewed by, I think historically, though there may be a little bit of debate, but by and large as a procedural grant of authority that allows shareholders to use the company's proxy materials to
communicate some sort of a message.
Yeah, exactly. Right. To solicit proxies on a proposal they intend to raise at the meeting without paying for their own solicitation.
Exactly. Right. And we'll talk about that because I have a couple other questions that sort of get to some of the broader implications of all this now that we've kind of talked about it. But we're going to do that after a quick break here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFloatAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to freefloatanalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at freefloatanalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Mike Levin. We've been talking with Kyle Pinder of Morris Nichols about shareholder proposals under Delaware law. And I think we talked pretty thoroughly about kind of the foundational law and reasoning for this conclusion that, you know, companies really don't have to include these in their meeting agenda and meeting proceedings. I don't think we forgot anything major there, right? Before I get to some big questions, is that right? Anything we left out?
No, I don't think so. I think we'll talk about the interplay of 14A I-1 here
the federal law and so forth.
Yeah, so I think that's right.
I do want to ask how you got the idea. What was the reason, you know, where this all came from? You know, when you because, you know, you're like a practicing lawyer. You have clients. You don't write, you know, legal papers for academic
I'm not an
journals.
academic by trade.
Right. You know, and this is I think this is scheduled to be published someplace, right?
Yeah, so I think it'll be published in the Michigan Business and Entrepreneurial Law Review,
sometime
likely
soon?
in mid-December, I think.
Oh wow! So this is
mid to late December.
This is happening, man.
Yeah, we're in the final site checking phase of the
peer review. You got 3 anonymous reviewers that are kind of looking it over, or maybe not. So
I'm not sure. I'm through the substantive edit. I don't know if it was peer reviewed or just
published.
Student reviewed.
Okay. Oh, cool. So, but where'd you get the idea? Let's talk about where this came from.
So I think that's for me, probably one of the more important parts of how this all fits together. The genesis of the paper is kind of simple. There's uncertainty regarding, you know, the future of the federal shareholder proposal process and Rule 14A.
Right.
As you know, as everybody knows, 14A is the rule that allows stockholders to submit those proposals for inclusion in the materials, so our company's proxy materials.
Right. And
the staff or the SEC, I think, you know, they've made comments over the course of this year, but starting in early in the year, a lot of lawyers and I think folks at companies and probably proponents were speculating that 14A was in for a major reform during the current SEC administration.
Right.
And that was after the commission publicized their Reg Flex agenda for the rulemaking agenda for the next, for this term. One of the I think it was only 3 or 4 things on there. One of them was a modernization of Rule 14A8. So that kind of confirmed that 14A8 was on the table, so to speak.
Right. To be evaluated and reviewed and maybe changed or eliminated. Who the hell knows?
That idea that 14A8 was in for a large overhaul or I guess potential repeal was kind of solidified during the Chairman Atkins' speech at the Weinberg Center that you all have talked about.
Right.
One of his parting words were, I'm also calling for a wholesale reevaluation of Rule 14A8 and whether it does, it achieves its intended purposes. Such as they were when it was adopted in the 1940s.
So, and this isn't new. I mean, there have been over many years different, questions and demands or whatever, mostly from issuers to we got to do something about this.
Yeah,
but it really got heightened in the past, I'm going to say, year.
Yeah, exactly. And that kind of from that, with that level of uncertainty, I started thinking about, I'm not quite sure what it's going to look like, but I guarantee no matter what flavor of reform the SEC pursues, there will be gaps that, either state law or issuers are going to need to, or may perhaps want to fill.
Or at least understand.
Ordering. Exactly.
Okay. Oh, interesting.
And
okay.
When there are gaps in, effectively in a governance regime.
Yeah.
Whether it's as the state or the corporate chartering architecture or the federal regulatory overlay, a lot of issuers fill those gaps by private ordering via bylaw or charter provision.
Okay. And so you were trying to establish the dimensions of what that looks like.
Yeah, exactly. So to the extent there's either question under the federal rules of, what you can do in your charter or bylaws to regulate these types of proposals, or if there just were no federal regime anymore,
right?
How can a company regulate proposals via private ordering?
Okay.
If to the extent it just, it wants to keep that as a means of intra-corporate communication that is, candidly less intrusive than a withhold campaign.
Okay. Oh, interesting. So basically sitting there observing all these potential changes at the federal level, you're asking yourself, okay, where's Delaware fit into this?
Yeah.
And
the charter bylaw amendments are the most likely place for a company to because Delaware doesn't legislate top down in terms of here's exactly how you're going to do it and what you're going to do in terms of, proxy access and precatory proposals.
Right.
So it's more often than not, I think almost universally, it's a grant of authority to companies, to private and shareholders to figure it out.
Right. Oh, interesting.
So under the current rules, Delaware law, I started looking at, I guess how could one privately order today if they were so inclined?
Right.
Charter probably the easier discussion, because you generally your charter is your preeminent corporate document that you can deviate from nearly any default rule in Delaware you'd like.
Okay.
If you have, if shares have an inherent right to vote, one vote per share, you can completely divest that in the charter. Right. So if you wanted to divest the right to propose a precatory proposal, or
put it there.
Regulations on it, put it there.
Right.
But that's great for IPO companies or companies with a 75% stockholder.
Right, exactly. Because the charter requires shareholder approval.
Exactly. It takes two to tango to change the charter, the board and the stockholder.
Bylaw is a different story. You could maybe put
exactly.
It in the bylaws. Okay.
Exactly. So the question was, all right, well, so for midstream public companies that are already out there, is a bylaw, a unilaterally adopted bylaw, no matter which constituency it's coming from, would that be a proper bylaw today if you did regulate more than just the time frame for submitting the proposal? If you did try to include an ownership threshold, you need to own X dollars,
or some sort of other procedural thing or whatever. Okay.
Exactly, or even like a substantive, like yes, you can bring governance related proposals, but you can't bring
climate
else.
Ones or something.
Exactly.
Okay.
So I mean, we'll see where the market goes on the actual terms of the bylaw, but the threshold question is, can you do it by bylaw? You just have so much more flexibility by charter.
Right.
If there's a fundamental or inherent right to propose precatory proposals, there's some uncertainty under the DGCF.
There's some limits of what kind of bylaw you can do here.
Yeah, because you're restricting a right. And there's a literal reading of the statute says you got to do that in the charter.
Some proponent will sue an issuer over that bylaw, and if the law is as they would like, they'd win, and the company would have to handle it. Oh, interesting.
Exactly, because public companies, fortune does not favor the bold when it comes to governance reforms and governance innovation for public companies.
Right.
So a company that wants to do something like this in the absence of a Delaware statute or a Delaware case, they're setting themselves up for a high likelihood, or at least a likelihood of potential litigation.
All right, cool.
So that's where that was at the end of the paper where I said, this is my view, and this is why you can do these bylaws today.
Yeah.
But to avoid the quote first mover problem, it would be beneficial for the market, for the Delaware legislature to say, yes, you can, in fact, regulate the submission of precatory proposals by bylaw.
Okay, interesting. All right, so we talked about how Atkins kind of name checked this whole thing in his speech, basically saying, hey, we're really rethinking all this whole precatory proposal deal at the federal level. But that was at the Gala Weinberg Center dinner and so forth is when he gave the speech. You were there, I think, right?
Yeah, I was there. I desperately needed CLE credit because I have to report in December. So I was there for the symposium during the day, and then I attended the dinner.
So you were at the dinner where the chairman of the SEC is talking about your paper.
Yeah, it was both, flattering and humbling at the same time as, a Delaware lawyer being.
Did you kind of see that coming, or were you sort of surprised?
So I was surprised that the chair of the SEC took that much notice of my paper to kind of use it as at least part of his argument, part of his argument, and his call to, I think some people view it as return 14A8 to its roots.
Right.
To look at it as first you have to start with state law and then go to 14A8.
Right.
14A8 wasn't meant to give just a broad referendum right on environmental and social proposals.
Of course. All right. So that must have been kind of fun.
It was, it was both cool and horrifying.
Like you're at a table with your partners and they're saying, did he just talk?
Because I had some people looking at me glowingly. I had some people looking at me like, daggers. So it was
what happened.
That was the horrifying part of, seeing some of the law professors look at me with a little bit of disdain.
Right. So now the other question I have is that about, the whole reaction is, so the paper's been out there for at least a couple months, or whatever. What have you heard? What kind of feedback have you gotten? What have you gotten? Some bricks thrown at you, or what's been the reaction here?
So both my wife and my homeowners insurance company are both happy that I can report that our windows have not been bricked or,
Great.
Or egged.
Right.
I've had a lot of conversations with in-house lawyers and, public company advisory lawyers,
Sure.
the big firms who talk to issuers, kind of just about the article where, how Chairman Atkins framed the question up and what, just the likely next steps could be if someone decides to get an opinion from a Delaware law firm to the extent they'd issue it. Right. And seek to exclude a precatory proposal on the basis that, shorthand precatory is improper.
Okay. Oh, interesting. All right. So there's been go ahead. Yeah. Sorry.
So one of the topics I talked about with these lawyers and in-house folk is, is it any precatory proposal? Are we gonna see every company seek to exclude every precatory proposal on the basis of Kyle's bright idea? And I think for a lot of the reasons that I think have talked about in some of the blogs and papers and on the speaking circuit to date.
Yeah.
I don't anticipate it being a death knell for all precatory proposals. Two reasons for that is one, there's yes, you have the SEC saying it's we'll let you exclude it, and yes, you have the support of Kyle's paper that says, it's not proper.
Yes.
But there's still always litigation risk, and some people just don't want to take litigation risk either on the
some
question.
issuers will not want to take that litigation.
Yeah, exactly. Right. Whether it's in the form of the certified question or it's, in a later litigation. And even if, the Delaware Supreme Court and whatever court looks at this, agrees with me, there's always going to the risk of litigation that, just because you can in a situation doesn't mean you always should.
Always will. Right.
Yeah. So there's that kind of litigation risk. Then there's just if the company's too heavy-handed on, let's say, a governance proposal that's about destaggering. We request you destagger, and the company excludes it. Well, what's that investor backlash going to look like at the the next annual meeting?
Right. They may be thinking, these issuers may be thinking down the road that this is an easier way to deal with these questions than proxy.
I'd rather hear about it from a proposal that may or may not pass this year that I can I have some discretion on how and if to implement, as opposed to next year something more concrete, like a withhold campaign or something like that, or got like a proxy contest, which that's the kind of a little bit of a nuclear option, but. Those are the kind of the judgment calls I think companies are thinking through and being a little bit more judicious with the possibility of excluding a precatory proposal under 14A8 I1. And I do think the SEC was thinking along those same lines when Chairman Atkins gave his speech, because he did focus on the environmental and social proposals.
Right.
He quoted some data that said, historically they don't get as much support. They don't pass nearly as often as governance proposals.
Right.
And they are the proposals that get the most heat from the market.
And the most opposition, basically.
And even the SEC's kind of been, over time, when they were looking at proposals not on the broader, are they just generally precatory proper, but they were looking at it in terms of a more proposal by proposal basis. One of the main ways you get an environmental or climate change proposal out is to say it relates to our ordinary business.
Oh, that's the main way to exclude it. Yes, right.
Exactly. Yes. So there's a Rule 14.8(I)(7) allows a company to exclude a proposal that relates to ordinary business. There's an exception that if it involves a significant policy matter,
right,
then it will not be ordinary business. And the SEC has the guidance on, what's ordinary business and how to apply the significant policy exception has been back and forth.
It's gone all over the place.
So I think this is also an acknowledgement that the SEC doesn't want to be the mediator for figuring out ordinary business and,
right. So
what a social policy is.
So it's going to eventually, to the extent it falls to Delaware doesn't have a whole lot of guidance either, based on what we've heard from this research. So if you've gotten, presumably you've gotten some criticism, some is there a way to sort of summarize how people have objected to your findings, or is it too early?
I think it's a little early. I think a lot of the objections haven't been necessary to the findings. It's just the potential that Rule 14.8 may not be available or as available. Though I think if I had to, I think it was the end of last week or sometime last week, I saw a blog post or an open letter to the SEC talking about my article, or the draft article. And I think the biggest piece of criticism or disagreement is that just because Delaware law is silent doesn't mean it's not allowed, and 211B is very broad.
Oh,
so it's kind of that. It's kind of like it's that framework question I started with, which is, where do you start from? Do you start from a place of board-centric governance and director primacy, or shareholder primacy?
Got it. Oh,
if it's the latter, then I imagine that is how a court would probably come out, which is But if it's, Delaware law to date at least has been more board-centric. So kind of reading the tea leaves from how the courts have deferred to management in certain situations and in many situations.
Right.
I think based on that, that's why I think my framework is the better way to think of it under current Delaware law.
Got it. All right, cool. Hey, we're running out of time, but I have a couple other quick questions that are only barely related. So I wanted to know, again, you don't write papers for a living. You deal with clients for a living, right?
Yep.
So your law practice at Morris Nichols, but you just said a little while ago you don't really go to Chancery Court, right? You're just
I think I've been a former Delaware jurist referred to what I do and people like me as being a telephone lawyer.
Oh,
we just our main role is advisory and counseling.
So you sit at the desk and sort of help people write bylaws, help people interpret statute and so forth. But you're not the one.
Exactly. And then I do some transactional work in addition. So
cool.
I help out with public company M&A and things like that.
So you'll do deals and so forth, but you don't actually go to Chancery Court to litigate this stuff. You have partners for that purpose.
Correct. Yeah. So, to the extent that comes up, I'll be in the background making sure it's the train stays on the tracks. But you won't see me in court.
Cool. All right. And then you've been at Morris Nichols for your whole career. Tell me a little more about some of the origins of all this.
Yeah, so I've been at Morris Nichols. I started just over 10 years ago at the end of the summer in 2015. I was a summer associate at Morris Nichols, and I'm a lifelong Delawarean, so it made sense for me to stay home and stay near my roots. And I always found corporate law interesting. We had family friends who were prominent corporate lawyers. So
interesting. So you went into the state business.
Exactly.
You weren't a chicken farmer, so you decided to go into corporate law.
Exactly. And I at the time it was soon to be my fiance, now wife and mother of my two kids.
Yeah.
She's also a native Delawarean, and she is very much I refer to her and myself too as a country mice.
Oh,
meaning we don't necessarily want to be living in the bustling metropolis of New York or DC. So
there's
Wilmington's a good combo.
There's plenty to do in terms of what you chose in Wilmington. That's plenty.
Exactly.
So all right, well, this is great. This is wonderful. So I think we're gonna have to wrap up here. I hope you've enjoyed. Sort of explaining what you had in mind here and sort of figuring out what's next. Probably there's some bylaws to write and there's some more litigation to look at and so forth as we work through this. Does that sound right?
That sounds right. I think at least for me, my next project will be just trying to figure out what that type of precatory proposal bylaw looks like that both, achieves the goal I'd like, but has the compromise effect of making everybody a little unhappy and happy at the same time.
Exactly. All right, cool. Well, we're going to wrap up then. As we said, Kyle, it's been great talking to you about shareholder proposals and Delaware law and these other subjects. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. I've been talking to Kyle Pinder, who is a attorney and partner at Morris, Nichols, Arsht and Tunnell. Did I say that right? Tunnel in Wilmington, Delaware. You can find me, Mike, at theactivistinvestor.com, and you can find Kyle at Morris Nichols, one word, morrisnichols.com. Our podcast is produced and distributed by Free Float Media. Thanks for listening. We will talk again soon.